SJC-12711, Plymouth Retirement Board v. Contributory Retirement Appeals Board, and others.
Good morning, Your Honors.
Why don't you wait 1 second till we're all set, until the clock runs. We appreciate your enthusiasm, but hold on to it for one brief moment. All right, now, release your enthusiasm.
Thank you, Your Honor. My name is Andrew Batchelor. I'm an Assistant Attorney General, and I'm here on behalf of the Contributory Retirement Appeal Board, or CRAB. May it please the Court, I'd like to start with the statutory scheme as a whole for Chapter 32, some big picture ideas behind the statute, and then move on to the plain language of the subdivision 4 to B and C. We're dealing with contributory retirement plans. Municipalities can set up these retirement systems that are funded by contributions from members. And those contributions are made through regular deductions from the members from their paychecks. And members can be full-time employees, but they don't have to be full-time employees. The legislature left it to the individual retirement boards to decide whether or not they would allow non-full-time employees to be members. And that includes part-time, provisional, temporary, provisional, seasonal, or intermittent employment. And all those different kinds of non-full-time employment can be members of a retirement system if the local board says they can.
But they don't have to pay.
No, they do, Your Honor. This is under Section 3, Subdivision 2D.
I'm not talking about crediting. I'm talking about during the time that they are part-time employees. They don't have to pay in order to be part of the system, do they? Or are they not part of the system?
No, I apologize, Your Honor. I completely misspoke. Yes, they do have to pay. Members are required to pay. The deductions are set forth in, Section 22, and it requires members to have deductions made, and so that would be any members, whether they're full-time or non-full-time, they're required to pay.
So this fellow, what happened with him?
He was not a member at the time. He was a intermittent police officer, or a permanent intermittent police officer.
Would he have gotten a pension?
I'm sorry?
Would he have gotten a pension?
Did he have enough years of...
If he just stayed in that position, would he have gotten a pension without contributing to it? Did he contribute to it?
He did not. He applied for membership during that period and was denied. He was only given membership.
So if you don't have membership, you don't get the pension?
Yes, Your Honor.
Okay, got it.
So he was, I gather he was a reserve police officer.
He was a permanent intermittent police officer.
But basically, he was essentially available to be on call, and they could call him up to fill in for other officers periodically. Yes. But he did not have a regular, he was not a permanent employee, well, he was not a full-time employee in that he didn't have a regular shifts. They would call him in for particular shifts. Yes.
For this particular permanent intermittent employee, Mr. Gomes, there was a long period where he was working regularly, but his status was always that of a permanent intermittent employee during the 5 years in question. He later became a full-time employee.
So permanent meaning that he is there for an indefinite period of time, and intermittent meaning that they may call him for the summer in Plymouth because it's a busier time, but he may not be called in the winter.
Yes, Your Honor. Permanent intermittent was a civil service position for the town of Plymouth at the time with civil service rights, but he had no reliable work.
As I understand it, you're saying that 42B deals with criteria, 42C deals with payment. But in 4.1, when the legislature has a particular type of employee who's going to either have to make payment or not make payment, they do it within the same section. So why isn't 42B just a self-contained section?
42B, Your Honor, respectfully, I would characterize as a calculator. It doesn't deal with criteria. It just says that you have this problem where non-full-time employees are getting credit for service. How do you calculate that service? So it doesn't assign credit for any particular kinds of service. It just says that the local retirement boards are left to calculate how much credit a non-full-time employee should get for their non-full-time work.
But they mention the part-time, the intermittent police officers. They mention it in 42B. So
yes.
That raises the question of why 42B might not stand on its own and also deal with payment, or specifically by not mentioning payment, not require payment?
Because 42B is the process for which you calculate non-full-time work, both for members and non-members. So because 42B applies to intermittent employees who are already members, there would be no reason to talk about payment. Because again, you can be an intermittent employee who's a member, or an intermittent employee who's not a member, later becomes a member, and then tries to get your intermittent work counted towards your years of annual credits.
I don't understand how you become a member. Tell me about how you become a member.
You apply to the board, and the board determines whether or not you're eligible based on the criteria under Section 3 and their own regulations.
Why the sudden change in McAloney in 2013?
It wasn't a sudden change for CRAB, Your Honor. It was the first time CRAB had a chance to rule on it. And so that was, the position was presented to CRAB, and they said that they must be payments. In fact, this is what Plymouth Retirement Board was doing itself when Mr. Gomes first became a member. They ordered, they said you can become a member and if you make a payment for the 5 years you're seeking service for. And that was in 1998, and he paid over a period of 2 years for the deductions he would have paid had he been a member when he's a permanent intermittent officer. Then in 2003, there was a change of position by PARAC, and PARAC says, no, you don't have to pay. So following PARAC's directions, the Plymouth Retirement Board refunded the money, and then Mr. Gomes got to keep that money from 2003 when it was refunded.
It seems so unfair to charge this man interest. Well, it was your fault. It was your fault. It was not his fault.
It was not his fault, Your Honor, I agree with that, but he's actually getting quite a good deal because he got a
Good deal because he has to pay interest on something that was your fault?
He's only having to pay interest for 1 year. He was the order in 2014 requiring him to pay interest was only from 2013 when McAloney was decided to 2014 when he was ordered to repay. So from 2003 to 2013, he was able to keep the money, and he basically had an interest-free loan of that money for those 11 years. I'm not saying he wasn't jerked around.
You could look at it that way. I don't look at it that way. You could look at it that way, but I don't. Interest-free loan, I don't think is a way to look at it. I don't think that's very, very constructive.
I would suggest that everyone agrees it's annoying to get these decisions that change, and it's frustrating to him, but Mr. Gomes is not an appellant here, or he didn't bring this matter to the Superior Court, only the Plymouth Retirement Board did.
Could I ask about 42C for a second? I just don't, I understand 42B. It's about how much credit you can get, and for these intermittent permanent police officers, it's defined. But 42C seems to redo this for everybody. It seems to only deal with people where they haven't defined the amount of credit, doesn't it? It goes, the board may allow credit upon whatever proportionate basis it shall determine, but that doesn't really apply to permanent intermittent police officers, right? The first part of that, right? Because they get a certain determined amount of credit, or am I misreading that?
I would suggest it does apply to permanent intermittent police officers. They're a type of intermittent police officer, and I think it helps to look a little bit at the legislative history of this provision.
So there's some ambiguity about how much credit these people would be entitled to, and you need to determine that? Because you need 42C to apply to these officers, or as Justice Lowy says, 42B just operates by itself, right? Right?
We certainly need 42C to apply to these officers, yes.
Right. And what I don't get, though, is the first part of 42C applicable to these officers because of, unlike a number of these other employees, they have a defined amount of credit already in 42B, right?
Yes, they have a defined amount of credit in 42B.
So the first part of 42C then doesn't really apply to them, right? You want 42C to apply, right?
Yes.
But the first part of it doesn't seem to apply at all, does it?
I would suggest it doesn't. If I go to the legislative history briefly, Your Honor, 42B and 42C were part of the original statute in 1945, and they had the substantive provision that's new that matters is the guarantee of 5 years for permanent intermittent police officers and firefighters. So when 42B and 42C was first written, 42B leaves to the discretion of the local retirement board to determine the amount of
Right,
credit.
but then they change that, right? And then
Yes.
they say, and this is a statute that has lots of political sort of decisions contained in it, right?
Yes.
Public safety, people with a lot of public clout seem to do well in the retirement statutes, right? So it's not completely logical, this statute, right? It's reflective of the fact that public safety people with political clout tend to do well in parts of this statute, right? You can't just do this logically, right?
I would suggest you can, Your Honor. And if you look at the parts of 4.1 where certain groups are given credit without paying,
Right.
that is, I would say, not analogous to the proviso in 4.2b about the permanent intermittent officers. The direct analogy would be the proviso for seasonal employees, because there has always been the proviso for seasonal employees. And so seasonal employees, they get credit for a full year if they work at least 7 years.
And you're saying they're in section 1
Sorry, 7 months, thank you, Your Honor. They are in 4.2b, Your
or
Honor.
2B? So seasonal workers are in
Yes.
4.2B?
Yes, Your Honor.
Along with intermittent permanent?
Yes, Your Honor. So the seasonal workers were originally guaranteed a year if they worked at least 7 months in 4.2b, and they had to pay their deductions, whether they worked 7 months or 9 months, whatever their deductions were, they would have to be. So when the legislature in the 60s added a benefit for permanent intermittent police officers and firefighters, they followed the model of seasonal workers by adding the proviso to 4.2b for the calculation of time, rather than by adding another provision to 4.1.
So if Plymouth had decided early on, upon the beginning of Officer Gomes' employment, that we'll make him a member, and if he worked during the course of the year, say 4 months out of the year, he would have made payments equivalent to the 4 months that he had worked.
Yes, Your Honor.
So if he had been a member from day one, he would have paid essentially, in my hypothetical, pension payments of 4 months. And he would have gotten credit for the full year, or would have gotten credit only for the 4 months?
You would have gotten credit for the full year, Your Honor.
Full year, okay. So and that would have happened even if they had done it from day one. It's not the C provision, which says we give credit for all the time in which you were available to work, would have kicked in. So he would have gotten 1 year of credit and basically paid 4 months of work.
Yes, Your Honor.
And what you're, I gather, are saying is that, although that's not what they did from day one, when they do it at day or year 10, and they look back, he's going to be in the same position that he would have been had we done it at day one.
Yes, Your Honor.
Now, as to the interest, there was some footnote, and I was trying to find it without success, which said that the Plymouth Retirement Board has the discretion to forgive that interest.
Yes, Your Honor.
And whose brief was it in? I saw it, but I can't remember.
I believe it's in ours, but I can't remember. I can tell you the statute that it's in off the top of my head. It's Section 20, Subdivision 5C3.
Okay, and so basically, if we were to decide, well, is it a matter for us to decide, or is it a matter for us simply to say that if the Plymouth Retirement Board thinks it's unfair to do what Justice Lenk apparently thinks is unfair, which is make them pay interest when it's only because there was a change in position, do we have the authority to say that's what they must do, or do we only have the authority to say that they have the discretion to do that?
You only have the authority to say they have discretion to do that. My reading of the statute does not require sort of a proactive requirement, but I don't believe that's been raised.
Okay, but there's no doubt that if you were to prevail, they could say, we're not going to charge them for interest.
Yes, Your Honor.
What do we do with the Grimes case? I'm sympathetic to your argument that it's a contributory retirement system, so you shouldn't get credit for things that you don't contribute to. But the problem is Grimes seems to turn that on its head, that if you didn't work, you get credit without paying, but if you do work you have to pay. So how do we make sense of that?
Well, I would suggest that the legislature has addressed that issue by adding subdivision O to 4.1, which says that you need to earn at least $5,000 a year going forward in order to be eligible. So that addresses the person who doesn't work at all during their 5 years. They can't get credit. And so, but the question remains, someone who works more will make more contributions than someone who works less. I would have two responses to that. One is that although they're working more, they're also earning more. So their net take home is still greater. The other is, this is a problem that's been, to the extent it's a problem, it's been there from the beginning with the seasonal employees. The seasonal employees, whether they work 7 months or 9 months, they both get a full year of credit, but the one who works 9 months has to pay more in contributions.
Oh, I thought that Grimes was the case in which he was available all year and therefore was getting credit all year, but he actually didn't work at all.
Yes, Your Honor.
Under the formula, you only have to pay contributions for the time that you work.
Yes, Your Honor.
So for him, that was zero.
Yes, Your Honor. And so that rubs people the wrong way, to put it casually, and that can't happen for future cases because the legislature has stepped in and added 1O, which says you have to earn at least $5,000 a year. So there's, as was pointed out by Justice Kafka earlier, this is maybe not entirely fair in everything that it's done, and some people get benefits that others don't. But the 5 years of credit was a decision made by the legislature, and just like seasonal employees get a full year of credit even if they don't work the full year, and so different seasonal employees will get that 1 year of credit even though they work different amounts.
All right, thank you.
Thank you all very much.
Mr. Sacco, good morning.
Good morning, Mr. Chief Justice, members of the court. Michael Sacco on behalf of the Plymouth Retirement Board. I'd like to start where Justice Kafka was speaking, which was what CRAB has done in this case is interpreted the exact same language of a statute so that some individuals are required to pay for service that others receive at no cost. That simply violates at least 4 different tenets of statutory construction, Your Honors, and as Justice Lowry said, 4.2b stands on its own. As this court and the appeals court has said in hundreds of cases, we start with the language of the statute. The language of the statute has 2 requirements. You had to be on your respective list, which respective list is generally a civil service term. You're on your respective list and eligible for assignment. So it doesn't contemplate any work at all. And the reason for that, as I learned going through this case and speaking to clients and individuals affected by it, is because police officers and firefighters, they take tests, they get on lists so that they can someday be permanently appointed. They forego other positions of employment because they're hoping to get appointed to that permanent position. So it appears that the legislature has rewarded them by allowing those individuals who are in this particular circumstance with 5 years of free creditable service.
They don't use.
I guess I'd ask you, what's 4C doing then? If 4C isn't dealing with payment criteria, why is 4C there?
Well, 4.2c is there to deal with everyone other than permanent intermittent call and reserve police
It
officers.
says any employee in 4.2c.
Well, it goes on to define, 4.2c does go on to define various categories of employment. The words in the category of permanent intermittent reserve and call firefighters only appears in that one section of the 105 sections of Chapter 32. It doesn't appear in Section 3.2d, which Justice Gantz was talking about membership. The reason why Mr. Gomes wasn't a member in Plymouth was because he wasn't eligible. Because if you look at Section 3.2d, which gives a retirement board the discretion, not the obligation, to admit into the system less than full-time employees, they list temporary, intermittent, but they don't include permanent intermittent call or reserve, and there's a reason for that. The same reason they're excluded from 4.2c is because the legislature has made a decision, like it has in other sections. The Lawrence case that's cited in my brief from the appeals court, as you know, points out there are 32 sections and subsections of Chapter 32 that require payment, and there are 9 sections that require no payment.
On those provisions, do they say they're without payment?
It doesn't say without payment, it simply is silent on it. But clearly where the legislature intended there be payment,
How do we know that? How do we know that that's what the legislature intended?
because in the other, the 32 sections, Justice Lang, that require payment, they all say, and I'm paraphrasing, that the member must make contributions that would have been withheld had that person been a member together with buyback interest. In every section that requires payment, that's what it says. And in every section that,
Why would they put that in 42B, though? That's so crazy.
I mean, why would,
Why would the legislature put the exemption to 42B for these people?
well, I think that's a policy question, Your Honor, that
Well,
I
I mean,
think.
if you're looking at the policy is to have a contributory retirement system. So why would you ever read into something that exempts somebody?
Your Honor, I would probably agree with you that I don't think anybody should get anything for free. We make the veterans pay for their service who go over and risk their lives and get credit.
Peace Corps volunteers, too.
Yes, but the legislature has decided there are 9 different categories or 9 different situations in which someone will receive credit at no cost.
And it did
this
so
is one of them.
expressly in those instances, didn't it?
I'm sorry,
It
Your
did
Honor?
so expressly in those instances.
It doesn't expressly say they shall not pay, but
No, I
it,
said in the instances where there are exemptions, they were express exemptions.
yes.
This is not an express exemption.
Well, no, I think this is an express exemption because it says they shall be credited with this service,
They'll
period.
be credited, they're not, that's not what so what? So they're credited, everybody else has to pay if they're credited.
Well, Your Honor, if you take, those in 42B have to pay, then those in 41A and all the other sections that don't contemplate payments and don't specifically say, which none of them do, that they don't need to make payments, then everybody has to make payment for any service that they're going to receive.
Don't we have to be interpreting these cross-references? It's not as simple as you say, right? I mean, in order to determine whether you have to pay or not have to pay, we have to decide whether you're included in one of these cross-references that discusses who has to pay, right?
Well, actually, Your Honor, I do think it is as simple as I'm expressing for that reason.
I wish it were as simple.
Well, I'm sure that, I'm sure you'll go through all the statutes and the case law, Your Honor, but permanent, intermittent, call, and reserve, those 3 categories of employment are not specifically listed in 42C. If 42C was intended to be a catch-all, they wouldn't need to identify those specific titles that are in there, nor would 42B even need to exist. But I would suggest to you also that.
Well, 42B would need to exist because 42B provides this special 5-year special benefit, right? That other people don't have. So you would need 42B, even if 42C included your employees, right?
Well, that's true, Your Honor, although they very simply, the legislature could have taken the language of 42B and put it into 42C, and that way everybody pays. But in the case of the permanent intermittent call firefighters, they get the first 5 years guaranteed. But I would suggest to you that's not the correct interpretation, Your Honors. And the reason for that is when you look at the second proviso in 42B, the local option, it then goes on to say that if a municipality accepts that local option, that for each day that the individual actually performs duty, he will receive credit for each day that he actually works. So clearly, they're drawing a distinction between the person who doesn't work at all, which is the Grimes case, which I agree that Grimes cannot be reconciled at all with Gomes. And then the next 5 years, if the local municipality accepts it, credit can be granted for each day worked beyond the 5 years. But in either case, there is, again, no discussion whatsoever for payment.
I'd like to go back to Grimes for a moment, though. Certainly it's an anomaly, and it sounds like the legislature's addressed the Grimes problem. But as far as somebody who's an intermittent police officer but has never gone into work, why wouldn't the answer be, even though there was a level of unfairness to it, well, okay, he hasn't worked or she hasn't worked, let's put that situation into 42C and see what it says about payment.
Well, if 42C applied to Grimes, then he wouldn't I guess are you suggesting
He
that
wouldn't have to pay.
he wouldn't have to pay, but you get the credit for free?
Right, because you just put that circumstance into Grimes, that's what comes out. Doesn't seem very fair, the legislature changed it.
Well, I think Grimes was the correct decision in the sense that he didn't receive any compensation, but he was entitled to receive the service for free, not because he didn't receive any compensation. I disagree with Crabb on that. Clearly, Plymouth's position is, which was the position for the first 50 years of the statute until McAloney came out. And that was PERAC's position too, and PERA before PERAC, and the Division of Insurance before PERA was even created in 1983. It was always understood and applied, although admittedly, as it came up before, Plymouth, because it thought it needed to charge Mr. Gomes for the service, did so originally. Then when PERAC did an audit and told them that they should not be charging, I was involved in that conversation, I agreed with that. That was the way the statute had always been interpreted, that these individuals, for whatever reason the legislature decided, would receive that service for free. I think it's clear that there's nothing in the statute in 42B that even remotely suggests payment, even tangentially refers to Section 42C.
I agree with that, but could you explain why? Because I'm bothered by Justice Lowy's question, which references any employee. Can you walk me through why 4C? I'm just looking at the language of 4C. It says in the case of any employee of any governmental unit who is a member of a retirement system pertaining thereto, the board may allow credit upon whichever proportionate basis it shall determine. Does that exclude? And then it goes on, it says intermittent employment or service. Aren't they covered? What did 4C says that it's not applicable to?
Sure.
Yeah.
That first clause in 42C is talking about any current member of a retirement system. 42C pertains only to individuals. I'll use Plymouth as an example.
But your client is a member of a system, isn't he?
Right. So when he became a member of the Plymouth retirement system, 42C only applies to individuals who perform service within Plymouth, not if they worked in Carver or some other community, only within Plymouth. So if you become a member of the Plymouth retirement system, under 42C, if the board allows it, you are allowed to buy back and purchase credit for all that type of service that's then mentioned in the next clause.
Mm-hmm.
What is not mentioned in that clause is permanent intermittent,
But
reserve,
it
or
says
call.
it says intermittent employment. It goes on to say, for any previous period of part-time, provisional, temporary, provisional, seasonal, or intermittent employment. You say because it doesn't use the word permanent intermittent, that they're not covered?
Yes, Your Honor.
So that's the reason you say 4C doesn't apply?
Yes, Your Honor. There's a distinction between intermittent and permanent intermittent. And if there's anything I've learned in practicing 27 years with this statute, each word matters. And the legislature has put words in there for a reason and excluded others for a reason.
Do we have legislative history? Do we have legislative history?
There isn't, I don't think there's any legislative history in the record on this, Your Honor.
Not in the record, but is there legislative, have you looked?
I-
You said you've been familiar with this for
there's-
27 years. I mean, in that period of time, have you ever looked at
There's a
history?
There's a discussion, Your Honor, in the Colo case, Colo versus Crabb, which talks about a 1964 amendment, which applies to this case. But since that time, I don't believe there's been any substantive changes in the last 55 years.
How about when it was enacted?
How long ago was,
No, when it was enacted, we have legislative history about that?
well, as my brother said, 42B was originally part of the statute, but the language was different, and then it was changed in 1964. So it started in 39, and then the statute was changed from, I think, 31 to 32 and 45. So that's the legislative history of it. But in terms of this particular provision, it's been fairly constant for the last 55
Do
years.
you think we should read this paragraph in isolation?
I do, Your Honor. I think this paragraph,
Even though even that is in conflict with most canons of statutory construction, which suggests you read statutes as a whole to understand the parts.
well, you do read it as a harmonious whole, Your Honor, but it's clear that the legislature inserted sections in this statute that don't require payment. So it's not disharmony to find that this is one of those sections. In fact, the appeals court in the Lawrence case specifically mentioned this section, 42B, as being one of those sections that don't require payment. And
Since
Crabb
you've
was a
been-
party to that case.
Well, since you've been living with the statute for so long, do you have any theory on the pivot in McAloney by Crab?
I don't, Your Honor. I was counsel in the McAloney case for Worcester Regional Retirement. I have no idea why Crab decided, as my brother indicated, it was not the first case that was decided below at the Division of Administrative Law Appeals, but it was the first time that Crab opined on the issue. Obviously, we disagreed with it and didn't think there was any rationale for it. Also with McAloney, Crab also said that second proviso that I mentioned, which was a local municipal option, that even if the municipality didn't select that option, a retirement board could put that liability on the municipality by allowing that type of service to be purchased. So in our view, Crab went totally off the reservation in terms of what the statute had been interpreted and had been applied by the regulators and by the retirement boards for 40 years. I don't see any rationale other than what I think Justice Lank was getting to and other justices have mentioned, that it is a contributory retirement system. There's no dispute about that. Members generally contribute, in all cases, to their own retirement allowance. It's mostly funded by the pension fund, which is taxpayer money, which is the contributions submitted annually by the municipalities. But for whatever reason the legislature has decided, I hate to keep going back to this, but this is our case. They have said in 9 different situations, this is one of them, that no payment is required. I think there is a rationale for that, as I alluded to earlier, given the public safety and what they do. Plus, if they're not members of the system, those who actually do work, they don't have protection of a retirement system. They're out there putting out fires, breaking up fights, doing things that public safety officers do, and then once they become permanent employees, the legislature has decided that they should, as a reward perhaps, receive this service for free, what they've dedicated to those municipalities
Why aren't they
protecting
just
the people.
receiving credit for 5 years as the gift?
I'm sorry, Your Honor?
Why isn't it just the receiving of the credit?
Well, it is, they do receive the
But
credit.
the credit for which they have to pay for
Well,
ordinarily.
ordinarily, they would pay for it, but I
Don't get the
think,
credit without the payment, in other
well,
words.
but I think, again, Your Honor, I think the legislature has recognized that you can be on the list and eligible for assignment and not work. So there is a reward for that. And those people are not paid. And that is, the Grimes case is not an anomaly, Justice Kafka. I can tell you that a lot of big cities have reserve lists, but unlike Plymouth, which is a seaside community, people aren't vacationing in Malden, for example, where Grimes was. Malden's a wonderful city, but they're not vacationing there like they are in Plymouth. So you do have people all over the state who are on these lists waiting to be appointed, waiting to be permanent public safety officers, and it seems to me the legislature decided to reward them.
But if you come out of an academy and you're immediately a member of a police department, you're not a PI, you don't get that benefit.
No, you don't, Your Honor, but you get the benefit of being in the retirement system and being covered by the laws that cover you, and you accrue service that way. You're covered if you're injured, all of those things as being a member of a system, those benefits. So the only benefit, it seems to me, that the legislature could confer on individuals in this situation are giving them that free 5 years of creditable service in recognition that a large part of them didn't work.
That they were a PI.
Right.
Okay, thank you.
Thank you.